we're going to chat about the difference between W-2 employees and 1099 independent contractors, as well as the common question relating to its practical application, which is, why would I bother hiring anyone as an employee when I can just make everyone independent contractors instead? Hiring someone under independent contractor status is often perceived as more favorable to the employer because it has fewer benefits and protections compared to employee status. Let's dig in more specifically. Full-time employees are often entitled to benefits such as health insurance, paid time off, eligibility to participate in the company's 401k retirement plan, and workers' compensation. Plus, employers are responsible for withholding income taxes, paying Social Security and Medicare taxes, and complying with federal and state employment laws such as the Fair Labor Standards Act, or FLSA, which governs minimum wage and overtime, workplace anti-discrimination laws, and wrongful termination laws. Independent contractors, on the other hand, are simply not entitled to the same benefits or protections from the employer. Since they are considered self-employed, they are responsible for securing their own insurance and benefits, and they generally aren't covered by workers' compensation laws or eligible for unemployment insurance. In fact, even the federal anti-discrimination laws are not strictly applicable to 1099 contractors since they technically aren't employees, although a number of states have enacted laws that bridge this gap. So in other words, if you're an employer, don't think you have a free pass to be a bigot. Similarly, independent contractors are responsible for paying their own self-employment taxes. As a business, you would typically issue a Form 1099 NEC to contractors if you pay them more than $600 in a single tax year, but there's no withholding requirement. Just as an aside, it is these tax reporting obligations that are behind why independent contractors are sometimes referred to as 1099 workers in the USA, and employees are W-2 employees. The employer needs to report all payments to the IRS. Independent contractor payments are reported on a Form 1099, which is very simple and basically just indicates the amount paid out. The W-2 form that's issued to employees, however, is much more comprehensive, as the business needs to report not just taxable compensation, but also federal and state income taxes, FICA withholdings, 401k contributions, and more. So yes, as you can see, the perception that 1099 workers are less burdensome for the employer financially and operationally and legally and administratively isn't wholly without merit. But that doesn't mean that you as an employer can decide to rely exclusively on independent contractors for your business if that classification isn't appropriate. The government's guidance on independent contractor classifications has been chaotic over the past few years, as multiple sets of regulations were promulgated and then overturned. As of the end of last year, however, they have resettled on the traditional and most judicially favored model, which is a 6-factor test. This is down from a 20-factor test, although I'll confess that I think that the longer 20-factor test continues to have unofficial value in helping you understand the types of things that you should be looking for under the 6-factor analysis. Ultimately, what we're trying to get at with either test, but especially under the binding 6-factor one, is the economic reality of the situation. That is your worker an independent contractor and working for you is basically part of a larger opportunity for her to be in business for herself? Or are you exercising so much control over what she does that she's indistinguishable from an employee and the government would have good reason to suspect that the independent contractor status is merely a mechanism to avoid providing additional benefits? Let's discuss this 6-factor test in more detail. Number 1, opportunity for profit or loss depending on managerial skill. Because the company incurs the financial burden and control of its employees' work, employees generally don't face any risk of losing money based on how efficiently they complete a task. They are paid a stable wage or salary at regular intervals without deductions for business expenses. Indeed, if the employee incurs any such job-related expenses for travel or supplies, the company typically will reimburse him. Contractors have totally different stakes. They usually incur and pay for their own expenses without reimbursement from the company. If they overspend on supplies or they mismanage their time, they may actually lose money on the project. If they complete the work efficiently, they may make a nice profit. This dynamic is a key indicator of independent contractor status. Factor 2, investments by the worker and employer. Employees generally use their employer's tools, equipment, and resources to perform their work, and the company bears the financial burden of this investment. The company might issue the employee a company-owned laptop, which the employee is expected to return upon termination. And if the employee needs access to, say, Adobe Creative Cloud software to perform key tasks, the company will have already paid for it. Independent contractors are expected to make most, if not all, of these investments in tools, materials, software, and supplies for themselves. Factor number 3, degree of permanence of working relationship. Employees often work exclusively for one employer on an open-ended basis. The relationship may indeed be at will, meaning that the company can terminate the employee at any time and for any non-discriminatory reason, but the employment contract usually doesn't contain a set employment term or provision indicating that the relationship will terminate automatically once a specific project is completed. Independent contractors, on the other hand, may market and provide their services to multiple clients simultaneously, and their contracting agreements often, although not always, emphasize the limited nature of the engagement, defining the relationship as being for a specific project or a fixed period of time. Factor number 4, nature and degree of control. If your business will provide detailed instructions on how, when, and where work must be performed, whether it's coming from a supervisor or a set of written procedures or wherever, this is indicative of an employment relationship. Independent contractors have the freedom and discretion to determine how to carry out their tasks as they see fit, with minimal oversight or input from the business, as long as the deadline is being met and agreed upon business requirements for the final work product are fulfilled. If you, as the employer, need or want to exercise significant control over both what work is being performed and how it's done, so you expect the worker to use company-provided equipment, to be on site at the company's premises and work during the company's regularly scheduled business hours, and to report to a supervisor who can dictate the manner in which projects are to be completed in accordance with company policies, then you need to hire an employee and not push this off as an independent contractor. Factor number 5, the extent to which the work performed is an integral part of the employer's business. For the avoidance of doubt, this means whether the tasks being performed are a core part of the business, not whether the worker himself is so talented that he's indispensable. This is situation specific, but to provide an example, if your business is a software as a service company, the person programming and debugging the software and developing updates for the newest model is performing a service that is central to the company's primary purpose and operation. In contrast, the bookkeeper who spends 5 hours a week running the numbers and forwarding a couple reports to the CFO every month while doing something valuable is not working on the company's primary good and services offering. Factor number 6, skill and initiative. Now, skill and initiative can refer to a couple of things, but let's focus on the most common consideration, which is whether you provide any specialized job training to the worker. And note that you can't get around this by training your worker in advance and then sending him off to do projects in accordance with what they've learned. Employees are typically given a mix of formal training sessions and informal on-the-job training by the employer and are required to learn and abide by company standard processes and operating procedures. Independent contractors, in contrast, do not receive formal training from the business that engages them. They are expected to come into the role as experts in their field already with their own unique and individually developed set of methods and skills. Now, you may be wondering, who cares? What's the worst that can happen if you treat someone like an employee, even though you've structured the engagement as an independent contractor? Unfortunately, it can be quite serious. Misclassifying an employee as an independent contractor can result in significant legal and financial penalties. The IRS and the Department of Labor and state agencies all actively enforce proper classifications. Misclassification may lead to back taxes, fines, and liability for unpaid wages or benefits. Additionally, improperly classified workers could file lawsuits for denied benefits, overtime pay, or even unemployment compensation. I've had a few clients over the years who sought me out to help get their HR matters in order after having been through a reclassification experience. In most cases, due to making the wrong assumptions or risk-reward calculations themselves, although in one case it was due to hiring an idiot blowhard lawyer who misled them about his expertise in employment matters, and the fallout in all cases was rough. Any of them would tell you that it's better to just get the classifications right the first time around. This can be highly dependent on very specific facts and circumstances, though, and this general informational and educational video is not enough. The most important step to avoiding legal issues and ensuring proper classifications is to consult with legal counsel who regularly handles employment law matters in your jurisdiction and industry. You should document the relationship with every worker you engage. Form agreements that you've generated and can reuse are great, and you've heard me recommend them here many times, but you do need to separate form agreements for your employees versus the agreements for your independent contractors at minimum, and you need to be mindful that the terms accurately reflect the actual nature of the relationship. And since this can shift over time, it is best practices to regularly review worker statuses. Someone might start with you as an independent contractor, and that might be totally appropriate for the first 18 months they're there, but it's totally conceivable that 2 or 3 years down the road, they actually start looking and acting a lot more like your W-2 employees. I've even had some interesting situations where the reverse was true. When someone started as a W-2 employee, but several years later, everything about them screamed independent contractor. This became an issue of fairness and equitable treatment across both employee and independent contractor staff. Willful ignorance won't make underlying issues go away. Given the significant risks of misclassification, it's important to carefully evaluate the factors on a rolling basis and to consult with legal or tax professionals when necessary. Business owners, do you have a preference for utilizing independent contractors over employees?